The United States Supreme Court could decide whether to take the case Gonzalez v. Inslee. That has to do with the property owner who sued the state of Washington and Jay Inslee over the eviction moratorium, the near endless eviction moratorium that took place during the pandemic. Now, lower courts did not side in the favor of Gene Gonzalez and his wife, Susan. They're now hoping that SCOTUS will at least hear the case. We want to talk about that today. This segment is brought to you in partnership with the Rental Housing Association of Washington. One of the things they fight for are property owner rights. If you own property, maybe you're a landlord, do not proceed without becoming a member of RHA, rhawad.org. All right, so in Gonzalez v. Inslee, we want to have a legal expert on the show today to talk a little bit about this case moving forward. His name is Sam Spiegelman. He's associate counsel at the Citizen Action Defense Fund, and he is an expert in the area of property rights. Sam, welcome to Undivided.
Hi, Brandi. Thank you for having me.
Yeah, I should, in full disclosure, say you're also helping work on our case through CADIF, our public records lawsuit against the city of Seattle. This interview has nothing to do with that, but we do have that pre-existing relationship. But we want to talk a little bit about property rights today and really, generally at its core, the government trying to impose itself on property owners' ability to do with their property what they see fit and how they see fit. So there is an interesting moment coming up, June 20th. The U.S. Supreme Court is considering whether to hear a case out of Washington State, Gonzalez v. Inslee, and it has to do with our state's eviction moratorium. Can you give us the ins and outs of it? And actually, you used to work with the attorney who's on this case.
That's correct. Quick shout out to my old colleague, John Houghton at Pacific Legal Foundation. What's interesting about this case is our side, the property rights advocate side, has been trying to get an eviction moratorium case in front of the Supreme Court, and they've swatted a few of them down. We think this might be a promising one, and the rub of it is that Inslee, like a lot of left-leaning governors, imposed an eviction moratorium, obviously when COVID came about. But the nuts and bolts of it were you could not evict a person past even the end of a lease agreement. So it's not like there were extra protections for the purposes of preserving health and safety for months and months and months, and well after the ebb and flow of the epidemic, there were still thousands of holdover tenants, also known as squatters. So it's something that with this Supreme Court, a very property-friendly Supreme Court, they've been great, but you need to get the case in front of them. So on June 20th, they get behind closed doors. They decide what cases out of the batch that day they're going to take and actually hear in their next term. And we're hopeful, but to be a property rights advocate in America, you have to always be hopeful and be an optimist.
Yeah, for sure. So what would the Supreme Court be weighing in determining whether they want to take this case on?
Yes. So the short end of it is that we're just claiming sort of a straightforward takings violation. In the Fifth Amendment of the Constitution, there's what's called a takings clause. It says, "Nor shall private property be taken for public use without just compensation." Obviously, those are only 12 words, but like a lot of clauses in the Constitution, there have been thousands and thousands more words written on it and interpretations of it. And when you get down to it, what Washington was forcing landlords to do, and now there are a lot fewer landlords, especially mom and pop landlords in Washington, thanks to regulations like this. What it was trying to get them to do was force them to host tenants well past their lease agreement. Even in some cases, I know for sure this was in California, they even didn't let you remove squatters who had found their way into your property. So hopefully they take it, because this can't be repeated. I mean, we're talking about a transfer of many tens of billions of private dollars flowing from out of the pockets of landlords to tenants who, when you abide by your lease agreement and you're there for the term, it's all well and good. But these are tenants that held over well past the end of their term, and nobody's paying the landlord, so they've just had to foot the bill for this public service.
Yeah, I mean, it would have been different. I still would have disagreed with it, but it would have been different when you talk about the constitutionality of it, unlawful taking of private property for public use without just compensation. Now, if the government had, again, I wouldn't agreed with it, but had used taxpayer money to put it in the pockets of those landlords and give them just compensation for their lost revenue, this wouldn't be a case, right?
That's correct. There might be on the margins questions of did they give them the right amount of money? Was it fair market value? But that is the extent of it. And us property rights advocates do often say that we are as a judicial matter, we are okay with subsidization.
Yeah.
There's a different question of policy, whether that's actually the smart thing to do. But in terms of what the Constitution allows, yes, you can technically. Again, there's some carve outs, but you could force a person to host somebody potentially, but you have to pay them. I mean, you can't. A very strong principle in constitutional jurisprudence. It's called the Armstrong Principle from a 1960 case, and the Supreme Court said that the Takings Clause was designed in all fairness and justice. To not to force a small subgroup of the population to bear costs that are benefiting the public at large. So the same way that we all pay our taxes, we all benefit from taxes paid. There needs to be that sort of reciprocity when if they're going to host these tenants, then we all should be having to pay for it.
Yeah, yeah. And so just to be clear, this case was lost in the lower courts by Gonzalez, correct? Inslee prevailed in the lower court, so that's why it's being considered before the Supreme Court.
Yes. I'm sure with your case against Seattle, the courts here have something of a mixed bag record, especially when it comes to property rights. And yeah, it failed all the way up, and our state Supreme Court actually declined to hear it. So then it jumps to the federal Supreme Court.
Hey, Sam, I have full faith in the court that our case is before on public records issues. I actually, the city of Seattle has been knocked a lot on public records issues. So I'm fully optimistic they're going to see the light of day on ours.
Let me also, as a participant, caveat that I am talking more about historically the property rights case law in the state, but we're working hard at it.
Yeah. And Sam, just to end with this, you touched on it briefly, but what's at stake here? Obviously, because for Gene Gonzalez, this ordeal is behind him, so to speak, in the sense that we're not in this eviction moratorium for the pandemic. So what's at stake if the Supreme Court takes this case and rules for him or against him?
Well, if it could be monumental. What's funny is the Supreme Court has taken property cases that involve something as simple as running a cable through someone's apartment. The case was called Loretto v. Manhattan Teleprompter Corp., 1982. Just that it was actually argued that the damages was $1. And eventually, when it was remanded back from the Supreme Court ruled that landlord had a right to exclude the utility company from his apartment. It ended up only being $1 worth of damage. But so small cases can make for big splashes. But this isn't even a small case. This, for Washington state at least, but obviously the Supreme Court will have a full nationwide impact on their ruling. We're talking about the difference between a future where landlords the government comes up with any sort of emergency. Obviously, we're living in an age where everything tends to be an emergency, and can just ram through all these regulations and never pay landlords for hosting tenants. So it could be a turning point in what the government is allowed to do and on a grand scale. So it could end up being a very important case, what we call a landmark decision.
Yeah, and I would just add in, even though I said that was the last question, one of the things that's on my radar are the migrants, and asylum seekers and no place to put them. And you have cities right now in jurisdictions asking residents, will you host these asylum seekers? Maybe it's I don't want to say conspiracy theorist in me or I have this worry, given how much the government has done, that would become not optional or something. And so, is that way out of bounds to think that that's something that could come up?
No, you're right on the money. That is certainly a plausibility. If something like these eviction moratoriums are let stand, then yes, you can call, just like you called COVID an emergency, and I'm not disputing it, of course, was an emergency, but you could call a homelessness crisis an emergency, and then that would give the government carte blanche to tell people to host people in their homes, which not only goes against the Takings Clause, obviously, but it's sort of adjacent to the Third Amendment, little talked about, where you're not allowed to quarter troops in peacetime, but apparently it's possible to be made to host squatters.
Yeah, we might need an update to that Third Amendment. We might need to add a couple additional lines to that one.
Exactly.
All right, Sam, we appreciate it. Thank you for your time and expertise.
Okay, thank you so much, Brandi.
So again, that's Sam Spiegelman. He's associate counsel at CADIF, expert on property rights law. So we will be waiting patiently to see if SCOTUS decides to hear Gonzalez v. Inslee and weigh in on what I do believe is unlawful taking of private property for public use. I mean, the government declaring a state of emergency and basically saying, nope, you've got to just continue to house people, even if they're not paying rent, even if they have no proof that they were financially impacted by the pandemic, and we're going to let it continue on and on and on and not make landlords whole again. So it really seems like a complete invasion of property rights by the government. And I am very curious. If SCOTUS takes it, I feel like SCOTUS will be on the side of the property owner. The question is whether they're going to take the case up. That segment was brought to you by the Rental Housing Association of Washington. If you're a property owner, a landlord in the state of Washington, RHA can have your back to protect you against some of these insane policies. RHAWA.org, RHAWA.org. Become a member today.